This week has been the week, of course, of the 20th anniversary of the now known colloquially as the Mabo decision, and you as then Chief Justice presided over that decision, and there's been a great deal of media publicity this week and the revisiting of the case. And I suppose it is going to be the case that you're going to be very much remembered for as presiding over at the time. There was a great deal of controversy when the case went through. I'd like to hear in your own words how it was for you at that time with the presentation of the arguments and, of course, the arguments that were put forward by Eddie Mabo's lawyers. He himself didn't live to see the outcome of his role in that whole decision. But I'd be interested to know from your point of view, knowing the significance of all that you were going to be putting forward, how it was at the time to be sitting on the High Court bench with your fellow judges and presiding over that decision.
Well, you're looking for a feel-good answer.
No, I just want a truthful one. I am very interested because you would have known very well just how significant that decision was going to be.
Yes, but first of all, I could foresee that the decision would be controversial. But there were two things about the controversy that I didn't foresee. First of all, I didn't foresee that the controversy would not arise for about 6 months. That was because there was an intervening election, and as it worked out, the contending parties didn't want to make Mabo an electoral issue. The second thing is that when the controversy did arise, it was more ferocious than I thought it would be. I hadn't foreseen the extent to which the court would be criticised for the decision. The criticism, I thought, was highly exaggerated and in many respects completely unfounded. The notion, for example, that Indigenous people would be climbing over your back fence, staking out your backyard. But this was a criticism that was vigorously put forward.
Certainly in Talkback Radio it was.
Yes, exactly. And not only on Talkback Radio. But the important point, it seems to me, is that if you look at some of the recent programs, if you look at Q&A the other night, for example, where towards the end of the session they started to talk about Mabo, it seemed to me that it was common ground, that, Mabo was a good thing, that the criticism of Mabo was very considerably exaggerated, and that the result 20 years on is by and large the pastoral mining communities and the Indigenous people are working in a more or less cooperative fashion. The real difficulty, of course, is the delay in decision-making, and that delay is partly caused, of course, by the disputes as to ownership between the various tribes contending for ownership. And you can understand that because these people having a connection with the land, but it wasn't the close connection with land that we have with identifiable, precise boundaries, and therefore it's unavoidable. I think it was a decision for the good, but of course the decision as a judicial decision is not to be judged on whether or not it produced good results. The real question is, was it a sound decision from a legal perspective? And I've never had the slightest doubt that it was.
So you weren't troubled, for example, by what, well, perhaps I don't know whether you would have thought of them as quibbles or not, publications at the time by the Samuel Griffiths Society, where I know, for example, the late Sek Hume QC continually questioned this idea of, well, you can't prove continuous connection. He had a lot to say about that in his paper opposing, I suppose, ultimately the Mabo decision. That those sorts of objections didn't in any way trouble you at any point?
Well, no, that particular one doesn't, because that was a requirement of the decision that the Indigenous claimants establish a continuous connection with the land. Now, curiously enough, if you were asking me today Do I think that any part of the Mabo decision might be rethought? I would say to you, yes. The notion that there is an onus on the Indigenous claimants to establish continuous possession. I would be more inclined today to put the onus on those who are disputing the claim to title by the Indigenous people.
And how would you go about that? How would you go about saying, all right, the onus is on you, you might be a mining company, for example. How would you go about saying, all right, show me how you can prove this connection yourselves?
Well, I think all you have to do is to just reverse the onus, and then everything depends on the facts of the particular case.
Do you imagine many would be scrabbling to find some sort of justification accordingly, or?
Well, they might be, but...
Because they wouldn't be used to having the onus put on them in that way, would they?
No, they wouldn't be. But on the other hand, I think we know a great deal more about Indigenous identification with lands today than we did when Mabo was decided. And I think as a result of that, it wouldn't be as difficult to come to a conclusion about that issue.
There's been some interesting legal articles written in more recent years about the differences between actual ownership and what they sometimes call cognitive ownership. Were you reading much in those years about those sorts of questions and issues? Have you since?
I haven't read a great deal, but I have read something of it.
Do you think they, in any way, would have shed further light had you been reading those sorts of points being raised at that time? No?
No, I don't think so.
So something like the expression cognitive ownership, does that resonate in any sense with you? Some sense of a proprietorial interest in land without the actual ownership?
Well, I can understand the concept, but I'm not so sure how we would have dealt with it 20 years ago. And I think we still would have pursued the path that we did pursue at that time. I think in terms of land law, cognitive ownership needs further development before it becomes an accepted part of land law.
That's fair enough too. One thing you were saying to me earlier was the expectations of Indigenous people as a result of that decision, nevertheless, have been somewhat dashed following the Mabo decision and the subsequent Native Titles Acts over the years. So looking at it all these years later, do you feel, in a sense, that where things have got to in public policy terms, it's still not the outcomes that you might have hoped for, or they might have hoped for, rather?
I think that's true. But when I made that comment to you, I had in mind rather the extreme views that were being propagated about Mabo. On the one hand, the view that it represented an enormous advance for the Indigenous people, and on the other, the view that, well, it's jeopardising long-standing traditional interests in property. Both of those views being wrong, in my opinion. And I think that may have led the Indigenous people to think more was going to come out of the decision than actually came out of it. And then secondly, although I don't think the Native Title Act that was the subject of the first decision of the High Court after Mabo deprived the Indigenous people of anything that Mabo gave them, I think amendments to the Act introduced by the Howard government did have that impact.
I suppose, nevertheless, though, it was the symbolism of it that mattered a great deal to the Indigenous people.
That's what I always thought. That the two things that always struck me about Mabo was that it should have given the Indigenous people greater pride in their heritage, and their heritage, of course, did include an identification, a connection with the land, which played such a large part in their cultural beliefs, the spirit beings. And secondly, I always thought about Mabo, it demonstrated to the Indigenous people that the Australian justice system was capable, in an appropriate case, of delivering just outcomes to them.
When you say that, and then looking back over all the years in your beginnings in the law, could you have imagined
Not at all.
as that young man there in that photo, that you would one day be saying the very words you're just saying to me now?
No, I couldn't.
Did you have, in any stage of your career, some moment of epiphany, if you like, where you began to indeed grasp those finer and somewhat more intangible qualities that go into ultimately the decisions that you were ultimately to make when you sat in the High Court?
Well, yes, but I wouldn't say it was a moment of epiphany.
I mean, I'm being a bit dramatic, but I'm just wondering.
No, I think it was a gradual development, and in particular, a development that was associated with the High Court being cut loose from the Privy Council appeal, becoming the final court of appeal for Australia, and the evolution of a view as to the role of a final court of appeal, a view which ultimately I took with me to Hong Kong when I became a judge of the Court of Final Appeal in Hong Kong. The role of a final court of appeal, the Constitutional Court, is quite different from that of any other court, and it has to be recognised as such.
The symbolism of it is
Exactly.
very important.
That's right. Mm.
So yes, so as you say, that helped shape a lot of the sense of the import of your work accordingly. I liked, you said something a few moments ago about common ground. Do you imagine one day that may in fact turn into a practice right throughout the law when it comes to native title claims, that we will be able to say common ground, that is how our legal system views the coexisting, if you like, of colonial Australians and the first Australians?
I think so, yes, definitely. Mm.
Are we much closer, or do you feel in some ways we sort of go forward a couple of paces, we go back?
That's been the whole history of the law. We go forward a couple of paces and we take one step back. As long as we don't take 2 steps back or 3 steps. But that's the history of the law, partly because as lawmakers, judges are obviously handicapped. And they're also conscious of criticism. And once a court becomes, as it were, forward-looking, taking the initiative, that tends to generate a groundswell of resistance or objection. The end result on that, generally speaking on judges, is to retreat, hopefully to come forward again. But judges are not insensitive to public opinion, particularly when the public opinion is directed at the court itself and may have the potential to damage the foundation of the court. The foundation of the court really rests on public confidence.